My name's Matthew Harding, and I'm the Dean of the Law School here. Thank you very much for joining us this evening for the 2022 Peter Brett Memorial Lecture. My very first task this evening is to introduce Uncle Bill Nicholson Jr., who's going to welcome us to country this evening. Uncle Bill is passionate about sharing his extensive cultural knowledge within the broader community. He's deeply committed to Wurundjeri Woiwurrung traditions and cultural practices, and he's a strong advocate for the rights of contemporary Wurundjeri Woiwurrung people to access and practice culture on country. Uncle Bill was a Churchill Fellowship recipient in 2015, and that fellowship explored cultural practice and maintenance among First Nations communities in urban environments of salience here in Melbourne, of course. Uncle Bill was also among the Victorian delegates nominated to attend the First Peoples Assembly, which resulted in the Uluru Statement from the Heart. So a distinguished set of contributions. So it remains for me to thank you, Uncle Bill, for joining us this evening to welcome us to country. Over to you.
Yes, thank you, Matthew, and thanks to Melbourne University, and thank you to the organisers of tonight's very important discussion for actually incorporating a welcome to country at this gathering, because to me, for thousands and thousands of years, when people have gathered on this sacred land, there has been a formal ceremony to allow people to conduct their business, to yarn to the hosts, to feel safe and to utilise the sacred resources here on country. So it's a great sign of respect for allowing me to speak to you briefly before the lecture starts. And just keep that in mind, actually, because it's a real key ingredient to actually feeling truly welcomed to this land. Wiminjika, Gabamalamangil, Balabodialabo, Wallanjeri Balak, Niranamaga Gil Bill Nicholson. That's the language of my people. So Wurundjeri are my people, Woiwurrung is my language. Welcome and greetings. Good day from the Wurundjeri peoples or community. My name's Uncle Bill Nicholson. Now, I've got to give credit to my father who gave me, and some of you might have come across my sister, Mandy, who's very similar age to me, a great opportunity to learn what I call our story. And when I say story, that's our culture and history. And that allowed us to, I guess, gain a bit of confidence in our knowledge to be able to share that with the wider community. And actually the Wurundjeri community allowed me to take the title Elder, which to me is a great responsibility because I come from a long line of staunch men and women, which we call elders today. I'll name a couple of them to make them real. Billabulary was in charge of this place here where Melbourne Uni is now built. We've actually got a walk here, if you didn't know, named after him, in respect to him. He was the senior man of this place, and his son Simon Wonga, you might have heard of Wonga Park out in eastern Melbourne there. Simon set up what's on my shirt. If you can't quite read it, it says Corindurk. Now, Corindurk's a great symbol of our compromise, I guess, to survive, where culture was banned, I guess, and language. But it was an area for our families to reconnect and to build numbers again. So that's what I mean by a compromise. But Simon was our first land rights advocate. And because the Namanji or the whitefellas took all our land and did not give us access to any of it for 28 years, from 1835 to 1863 when Corindurk was set up. And in those days, you didn't have your local supermarket down the street. You had to have land to survive. His predecessor, William Barrack, now he's our most well-known elder past, I would guess. His face is on that building just over there. William's our first human rights advocate. So Wonga fought for our land, got some land, allowed our people to regather and rebuild. So once that was accomplished by Wonga, Barrack then took on the fight for basic human rights. And if you've never heard of these two individuals, well, three, because I mentioned three, I guess, individuals before, they're a real good starting point to start on your own journey to learn about some of the staunch elders and why we acknowledge our elders past for their strength and resilience And, myself, and I've got a cousin here, Sue Ann, as well, because we wouldn't be here without them for our survival. So, to me, there's really no more important reason, I guess, why we acknowledge our ancestors and our elders past. I'd also like to extend that to environmental leaders here today. You fellas get it. You understand that caring for country and the health of country relates to our health. I was just spending 3 hours down at Dights Falls with the film crew trying to explain about how we can potentially utilise our landscapes and our industries more sustainably than we are today, because unfortunately through climate change and some of the industry exploitation, our country is not well and it's crying out for everyone's help. And any environmental leaders here, I'd like to acknowledge you. Our community leaders, you're a community leader because you've earned the respect of your community, so I'd like to acknowledge you, Indigenous or non, and also cultural leaders. If we're to build something in this country, which you might want to take a language word away tonight, actually. This is one of my favourite words. Jindi Warabak Bullock. It means unity in the community. And to build unity in the community, that's through the ability to listen and build mutual respect through everyone's stories. And we're so multicultural today here in Australia. There's some amazing stories out there. Don't block your ears to it, open them up, and let's build one magnificent society, because one thing that I'd like to encourage everyone is to take our own personal responsibility to end racism, because personally I'm sick and tired of talking about it. It continues and continues and continues. Is it Australia's identity? We don't want it to be, but it's still alive and it changes its ugly face, and I think we all need to take our personal responsibility to eradicate it. And I also think too that we could all try our best to take our personal responsibility to care for this land in some form or another, because that was part of the law that was taught to every young boy and girl for hundreds and hundreds of generations on this land. Somehow we've forgotten it in the last couple of centuries, so let's bring it back and care for this country. Now, what I call the Birrarung dreaming, or what Bunjil, our creator, gave us, he gave us the land to care for, he gave us life to enjoy and the laws to live by. We had a very sustainable, knowledgeable, inclusive, healthy culture, and very responsible culture, as I mentioned. Now look, I'm an educator myself, so to me as an educator, you can't tell people what to think, you give them different points of view so they can make their own mind up. So the colonial invasion, either way you want to take that, one of my biggest frustrations is our economy was taken from us, and that was the environment. The English brought their economy and imposed it on our land and excluded us, really, if you think about it, until around 1967, when Australia said, well, all of a sudden, you blackfellas, you're part of the country, allowing us to create some form of self-determination, I guess, which we're still striving for. So that's my greatest frustration, being excluded. And when you're excluded, it's not just the ability to create an income, it's the ability to get an education, it's the ability to to create a future for yourselves. And that's why, unfortunately, a lot of the traumas in our community today still very much exist. And I guess the lessons from the past too. If we are a mature, educated society, let's learn from them and never let them happen again. The Welcome to Country ceremony is a law ceremony. It's like a passport. It gives you access to our sacred resources. It allows you to feel safe. Trust and respect is built between the host and the guest. And we do a smoking ceremony. The best way to explain that in a short time is fire is a physical cleanser of this landscape. We actually have a season related to it. The smoking ceremony is more of a spiritual cleanser, where my culture says that we don't believe that you come to an end, you just transition when you pass away from physical to spiritual. So we believe in good and bad spiritual energies or existence, so we do smoking ceremonies to cleanse the spirit of the person and of the ceremony ground before the ceremony is conducted. So won't be lighting fires up here tonight, so but I'd just like to say that to feel truly welcome, like I said at the start, respect to people, country and culture is part of the law, and it was never ceded to anyone. It's still here. So because I feel that respect, I'd like to say to you all, Wimidjika Wurundjeri Bik. Welcome Wurundjeri country, and I hope you enjoy the discussion tonight. Thank you.
Thanks very much, Uncle Bill. A word about the Peter Brett Lecture, and then I'll introduce our speaker. The Peter Brett Memorial Lecture Series is an annual series. It's named in honour of an eminent University of Melbourne alumnus, Peter Brett, who was born in 1918 and died in 1975. Peter Brett was a senior lecturer in this law school. He was appointed in 1955 and he was then promoted to Reader in 1961 before becoming the Hearn Professor of Law from 1963 to 1964 and Professor of Jurisprudence from 1964 until his death in 1975. Peter was distinguished by his scholarship both in criminal law and in legal philosophy, and also by his determination to contest injustice in the courts. He was one of the group of lawyers who stopped the hanging of Paul Tait in 1962, which was a landmark moment in the history of criminal punishment in this country. In a moment, I'll introduce our distinguished speaker. After Justice Martin delivers his address, I'll invite my colleague, Professor Heather Douglas, to facilitate a brief question and answer, and then my colleague, Dr. Eddie Cubillo, will offer a vote of thanks. So, to introduce our speaker. Our speaker tonight is the Honourable Wayne Martin, AC, KC. As many of you will know, Justice Martin has had a distinguished career in legal practice. He was admitted to practice in Western Australia in 1977. In 1984, he became senior litigation partner with Keele Brinsden in Perth, and then in 1988 he joined the bar. He was appointed Queen's Counsel in 1993, and of course he's now King's Counsel. And between 1996 and 2002, he was a member of the Law Reform Commission, and from 1997 to 2001, he served as the chair. From 2001 to 2003, Justice Martin took on the role of counsel assisting the HIH Royal Commission in Sydney. In 2006, he was appointed the 13th Chief Justice of the Supreme Court of Western Australia. In 2012, Justice Martin was appointed companion in the General Division of the Order of Australia for eminent service to the judiciary and the law, particularly as Chief Justice in Western Australia, but also for service to legal reform and education and to the community. He has held many positions as chair or patron and as the Lieutenant Governor of Western Australia. He was appointed the inaugural chair of the Judicial Council on Cultural Diversity in 2013, and he served in that capacity until 2017. He retired from the Office of Chief Justice in July 2018. Justice Martin, we're honoured that you're here this evening to deliver the 2022 Peter Brett Memorial Lecture.
Well, thank you very much. I'd like to thank Uncle Bill for his very generous welcome to your country. Uncle Bill, thank you very much for that. And given the topic of my address, it's more than usually appropriate for me to commence by acknowledging, as I always do, the traditional owners of the land on which we meet, who are the Wurundjeri people of the Kulin Nation. I pay my respects to their elders past, present and emerging, and acknowledge their continuing stewardship of these lands. I'm greatly honoured to have been invited to present this address in the memory of the late Professor Brett. Professor Brett was a great scholar, taken from his important work far too early, at the age of only 57. Nevertheless, he made outstanding contributions to legal scholarship in a number of areas of the law, including relevantly to my topic this evening, his many publications in the field of criminal law. I feel some small link to Professor Brett because he took up his first academic post as a senior lecturer at my old alma mater, the University of Western Australia, in 1951, which, as it happens, was the year before I was born. A few years later, as Matthew has mentioned, he moved to a similar position at the University of Melbourne before taking up a chair at this university in 1963. I feel another link to Professor Brett's work through the publication of his book relating to the wrongful conviction of Daryl Beamish for the murder of Gillian Brewer at her apartment in Cottesloe, a suburb of Perth quite near to where I live. Beamish was convicted on the basis of confessions allegedly made to police, notwithstanding that he is deaf and mute. Following his conviction and an unsuccessful appeal, Eric Edgar Cook, a notorious serial killer, confessed to murdering Ms. Brewer. However, a reference to the Court of Appeal was dismissed on the ground that the evidence against Beamish was strong and Cook's confession was thought to be unreliable. The modus operandi, which was mutilation with a hatchet, was thought to be out of character for Cook, who'd shot many of his victims, although other aspects of the crime were entirely characteristic for Cook. Cook repeated his confession of murdering Brewer, swearing that confession on a Bible on the morning he was executed. Professor Brett's book, published in 1966, attracted a great deal of attention to the case, but tragically, the egregious injustice, which he presciently identified, was not corrected until 2005, when a further reference to the Court of Appeal resulted in the conviction being set aside. Turning to my topic this evening, it would be much better if that topic was being presented by an Aboriginal person, but unfortunately it won't be possible to source an Aboriginal person with experience of service on the Supreme Court of Western Australia until my friend Michael Lundberg takes up his post as a judge of that court next month, he being the first Aboriginal person to serve on that court. And as that court has been in existence for more than 160 years, it is certainly about time that that occurred. Michael is a good example of the first point that I want to make this evening, very loudly and emphatically, and that is the point that the very depressing statistics to which I will shortly refer should not be taken as justification to stereotype and characterise all or even a significant number of Aboriginal people. Michael is an outstanding commercial lawyer and advocate who's been a senior partner in 3 multinational law firms. Although Aboriginal people are tragically overrepresented in the Australian criminal justice system, we must always remember that the vast majority of Aboriginal people are law-abiding, upright citizens who make a great contribution to the multicultural community which now inhabits this continent. Michael's mother, Sue Gordon, who I should also disclose is a friend of mine, and you gather from this that everybody in Western Australia knows everybody else in Western Australia, which is sometimes good, sometimes not so good. But anyway, Sue was Western Australia's first Aboriginal magistrate, and after years of outstanding service on the Children's Court, wrote a landmark report on the changes needed to improve care, safety and protection for women and children in remote communities. And believe me, some of the communities in Western Australia give a whole new depth of meaning to the word remote. Her recommendations were quietly and effectively implemented years before the noisy and bizarre intervention in the Northern Territory, which involved sending the army into remote Aboriginal communities, which was kind of a modern replay of the frontier wars with all the terrible imagery which that invoked. My point is that if you empower Aboriginal people to identify solutions to Aboriginal problems, you are much more likely to get better outcomes. And the same point is made tragically by 200 years of recurrent and conspicuous failure of policies designed by non-Aboriginal people. Sue and Michael together illustrate a third point. That point is that there are many outstanding Aboriginal people all around Australia, and the general community can be confident that they are well and truly capable of taking a governance role in the future. And that point is pertinent to the topic of constitutional change, which I'll come back to later in this address. But I remind us all, of course, that Aboriginal people governed their own communities for 60,000 years until they were forcibly dispossessed of their country a little over 200 years ago. Hence the title for my topic this evening, which refers to 200 years of injustice for Indigenous Australians. The point which I hope will emerge clearly is that it is a gross mistake to regard injustice to the first Australians as an artefact of history. That injustice is very present, very real and continuing, and according to the data, with one very encouraging exception, is getting worse. Now, the data that I will skim through briefly, I hope, is drawn from 2 sources, both recent. The first is the National Closing the Gap report, and the second is the Victorian Indigenous Affairs report. Both were published within the last couple of months, and both published data gathered up to the 30th of June 2021. I'll start with out-of-home care because, unfortunately, the relationship between kids in out-of-home care and engagement with the criminal justice system is very clearly demonstrated. The National Closing the Gap report published figures per 1,000 Aboriginal children. 2019, 54.2 were in out-of-home care. 2021, 57.6, so a slight increase, but what that means is nationally about 6% of Aboriginal children are in out-of-home care. Turning to the Victorian data, in 2008, per 1,000 children, there were 34 Aboriginal kids in out-of-home care and 34 per 1,000, 4 non-Aboriginal kids, so a ratio of about 9 to 1. So an Aboriginal kid had 9 times as much chance of being in out-of-home care. Last year, from 34 per 1,000, the figure had climbed to 135 per 1,000, which is an increase, of course, of about 400%. In the same time, non-Aboriginal rate had gone from 4 to 7, which is an increase of less than double. So the ratio that used to be 9 times has increased to 20 times. So last year, an Aboriginal child in the state had 20 times more chance of being in out-of-home care than a non-Aboriginal child. And that rate, 135 per 1,000, is 13.5%. And that means that a bit more than 1 in 8 Aboriginal children in this state is in out-of-home care. So if everybody in this room was an Aboriginal child, about 8 of you would not be with your family. Now that is a terrifying statistic. It is symptomatic of I think, a very poor portent for the future. And of course we know now scientifically that childhood trauma, which many of these children would have been exposed to, has a significant impact on neurological development because the brain is plastic and develops by reference to experience. So a lot of those kids are going to have neurological impediments, something I'll come back to. The figures in Victoria are dramatic, but unfortunately they reflect a trend all around Australia. And the dramatic explosion in out-of-home care for Aboriginal children is something that, in my view, needs the urgent attention of policymakers. It also gives rise to a significant ethical dilemma, to which I will return. So let's have some good news. The good news, and possibly the only good news, relates to rates of Aboriginal children in juvenile detention. So at a national level, the rate per 100,000 in 2019 was 32. 2 years later, in 2021, the rate had gone down to 23 per 100,000. Now that is a dramatic decrease. Now before we get too excited, we must remember that the 2 years in between were affected by lockdowns, and so crime rates did go down. But the reduction in crime can't explain that dramatic reduction. So very rapid and significant progress is being made in keeping Aboriginal children out of juvenile detention, and that's terrific. We don't know exactly from this data what other arrangements are being made for the children that would otherwise be in detention, but we can reasonably assume that whatever those arrangements are, they can't be nearly as destructive or damaging as being in juvenile detention. So that is a real glimmer of hope. Turning to the Victorian data, in terms of offending rates, between 2008 and 2021, youth offending by Aboriginal youth decreased by about 24%. By non-Aboriginal youth, it decreased by about 58%. So that an Aboriginal child in Victoria has about 6 times as much chance of being apprehended for committing an offence than a non-Aboriginal child. If we turn to detainees, the national figure is reflected in Victoria, where there's some good news. 2 per 100,000. In 2008, 18 Aboriginal children were in custody. Last year, 10. So that's a significant reduction of more than almost half, 44%. Non-Aboriginal rate went up to from 1 to 1.5, so that was a 50% increase. But there's still, of course, a significant difference, so that an Aboriginal child in Victoria has 7 times as much chance of being in detention as a non-Aboriginal child. That's pretty good compared to Western Australia, where the ratio is 20 times. So an Aboriginal child in Western Australia has 20 times as much chance of being in detention as a non-Aboriginal child. Or actually, it's probably more like 30 times as much chance. And consistently, in Western Australia's only detention centre, 75% of the kids are Aboriginal, compared to about 4% of the general population. Moving on to Aboriginal adult incarceration, at a national level, the number went up by about 4% between 2019 and 2021. Significantly, that rate is more than its 2,223 per 100,000. That's more than double the rate of Aboriginal incarceration at the time the Royal Commission into Aboriginal Deaths in Custody reported in 1991. And of course, that Royal Commission made 300 recommendations, all of which were intended to reduce the Aboriginal imprisonment rate. Notwithstanding those recommendations, it has doubled over the last 30 years. If you do the male-only rate in Western Australia, that rate, Western Australian rates are significantly higher than national rates, and of course male rates are higher than female rates. So the rates for males in Western Australia is about 7,000 per 100,000. Again, if you're quick at maths, that means that tonight 1 in 14 adult Aboriginal men in Western Australia will spend tonight in prison. That rate of incarceration arguably puts adult Aboriginal men in Western Australia amongst the most incarcerated people on the planet. It's a rate that's comparable to the incarceration of African American men in the USA. For those of you who are aware of these things, the USA, the home of the free, leads the world in locking people up by a very significant margin. It incarcerates a greater percentage of its population than any other country by a significant margin. And amongst the people incarcerated in the US, African American men are the most significant group. But adult Western Australian men are incarcerated at a rate that's comparable to African American men in the US. Let's move to adult females. In the Victorian data, offenders per 100,000 women, the rate of offending went up between 2008 and 2021 by about 64%, pretty much the same for non-Aboriginal women. So there was a significant increase in offending by women over that period. In relation to prisoners, though, the figures are dramatic, so that in 2008 per 10,000, there were 11 Aboriginal women in prison. Last year there were 27, so that's 27 per 10,000. That's an increase of 145%. Comparable rates for non-Aboriginal women were 1.1 and 1.2, so that in 2008 an Aboriginal woman had 10 times as much chance of being in prison in Victoria. Last year an Aboriginal woman in Victoria had 23 times as much chance of being in prison as a non-Aboriginal woman. And Aboriginal women around the country are the fastest growing prisoner cohort by a mile. And in Western Australia, 50% of the female prison population is Aboriginal compared to 4% of the general population. Moving on to adult males, in Victoria per 10,000, between 2008 and 2021 in offending, there was an increase of about 45% for Aboriginal men, for non-Aboriginal men about 37%, so the rates were comparable. But still, it's the case that an Aboriginal man has 6 times as much chance of being apprehended for committing an offence in Victoria as a non-Aboriginal man. Prisoners per 10,000 in Aboriginal prisoners went from 164 per 10,000 in 2008 to 356 in 2021. So in 13 years, the rate of Aboriginal incarceration of adult men in this state doubled, just in 13 years. And what happened to the non-Aboriginal rate was it went from 19 to 23, so it increased by only 20-odd%. So what that meant was that in 2008, an Aboriginal man had 8.5 times as much chance of being in prison as a non-Aboriginal man. Last year, 15.5 times as much chance as being in prison as a non-Aboriginal man. Western Australia, it's 20 times, so Aboriginal men in Western Australia are about 40% of the prison population compared to 4% of the general population. Another very significant change has been in relation to the remand population, so that in 2008, about 22% of the Aboriginal prison cohort was on remand. Last year, 46%. So almost half of the Aboriginal men in prison in Victoria last year were on remand. That is, they hadn't made, either they'd been refused bail or they couldn't meet the conditions of bail, or perhaps they chose not to go on bail because they thought they'd commenced serving their sentence. And the same, there's been a doubling of remand rates in relation to non-Aboriginal men as well. Now these figures are, of course, shocking. They involve massive expenditure from the public purse, and in rough terms around Australia it costs between about $120,000 a year to keep an adult in prison. For juveniles it costs between $400,000 and $500,000 a year to keep them in juvenile detention. And even when juveniles are being dealt with not in detention, it is very expensive. In 2008, the Auditor General of Western Australia counted the coppers and estimated that of the 250 children in that state who received the most attention from the juvenile justice system, they would cost the state of Western Australia $100 million. Now that's $400,000 a year in 2008 dollars. You could call that $500,000 a year. So what that tells you is that we could send those kids to Geelong Grammar and send them off to a Swiss finishing school and still have change. But instead, we put them in juvenile detention and custody, and we know that the very likely outcome of that process is they'll graduate into an adult prison rather than keep on costing the state money. So we're spending an awful lot of money and it's not making any real difference. Recidivism rates are very high, generally around Australia. They're about 60% across the board. For Aboriginal men it's higher, it's up to 80%. So that most Aboriginal men who are in prison have been to prison before, and it's very likely that they'll go back again. So we are spending vast amounts of money and making little or no difference. So why is it so? Why are these figures so bad? There are, I think, 2 short answers. First is, and this is an inconvenient truth, but it is that Aboriginal people are overrepresented amongst those who commit crime. The second is that Aboriginal people are at a great disadvantage in the justice system of Australia through what I call systemic or institutionalised disadvantage. And I think we are still a very long way from the point at which we can credibly say that the Australian justice system provides fair and equal treatment to Aboriginal people. But let's start with the first of those reasons, and that is the fact that Aboriginal people are overrepresented amongst those who commit crime, and ask ourselves why. Well, the short answer is that crime is a function of social disadvantage, and tragically some Aboriginal people are amongst the most socially disadvantaged people in Australia. There are, however, some special factors that apply to Aboriginal people and exacerbate the disadvantage which they suffer. Some are historical, some are contemporary. Historical factors include dispossession, alienation from land and culture, brutalisation, marginalisation, family fracture, including the stolen generations and institutional abuse that we know Aboriginal people suffered in those institutions, family dysfunction evident in the shocking out-of-home care figures that I've identified, and victimisation. We hear a lot about Aboriginal people being overrepresented as offenders. The fact is that most Aboriginal crime is committed against other Aboriginal people, so that Aboriginal people are grossly overrepresented as victims as well. And anecdotally, it's my impression that this massive growth in offending by Aboriginal women is probably because Aboriginal women are grossly overrepresented as victims. And so when I visited Broome Prison a number of times in my former role, I saw Aboriginal women incarcerated for various offences, alongside the men who were incarcerated because of the domestic violence that they had perpetrated against those Aboriginal women. So there are a number of other factors, and what I would call multifaceted disadvantage that Aboriginal people suffer, and it starts even before birth. Fetal alcohol spectrum disorder is something I've spoken a lot about in Western Australia because it is significantly under-recognised, I think, as a factor. It's a particular condition, of course, that's difficult to diagnose for a number of reasons. Because it's a spectrum disorder, there are various symptoms, and reliable diagnosis requires reliable history of maternal alcohol consumption during gestation, and for obvious reasons that those histories are very hard to obtain. But the condition is, of course, a condition which produces a permanent neurological deficit. There is no cure for the condition, so all that we can do is identify people who suffer from it and provide them with care and protection and perhaps some protective behaviours. But of course, because these people suffer this condition through no fault of their own, it is very relevant to the sentencing process because it's a significant mitigating factor. But it's under-recognised. People haven't been looking for it. So how prevalent is it? There was a study conducted by the Telethon Kids Institute at Western Australia's only juvenile detention centre, and they discovered that the majority of the children assessed in that detention centre had some form of neurocognitive impairment. That's a majority. So over 50% of the kids there had some form of neurocognitive impairment. And again, I'd go back to the point I made earlier. Scientifically now, we know that trauma impedes neurological development in a permanent way. 50%. These kids need treatment. They don't need punishment. But because of the difficulty of diagnosis, it was difficult to ascertain which of those 50 or more percent had FASD as compared to some other form of neurological deficit. But the researchers estimated that 36% of all the children they assessed suffered FASD. That is the highest recorded incidence of FASD anywhere in the world. The previous highest record was a study that was conducted in the Fitzroy Valley in the Kimberley, which also showed shocking rates of FASD, significantly higher than anywhere else. The children which were assessed also had very poor levels of general health, very often showing signs of physical trauma, scars and poorly healed injuries from risky behaviours or self-harm, hearing loss and difficulty of sleeping. A high proportion of the children had a history of trauma, including family members who were incarcerated, a single or perhaps no parents, histories of substance abuse and chronic illness within the family. 25 to 30% of the participants in the study had a motor skill impairment, which is obviously problematic because for a lot of these children, their only potential employment is in the area of manual labour. And 50% of those surveyed had a severe language disorder. That's half of the kids had a significant issue with language. Now, results like this ought to shock, but the fact that many of us who've worked in this system are not terribly surprised by these results shows how hardened we have become to the extraordinary levels of disadvantage suffered by some of the most marginalised and traumatised children in Australia. These are kids, I emphasise, that need care and treatment. They don't need punishment. So what are the other, starting from moving then beyond the time of birth, what are the other areas of disadvantage? Well, we know what they all are through the Closing the Gap reports. Low birth weight, poor levels of infant health, poor levels of school participation and retention, but there are some promising signs in this area. School retention rates have gone up, so that's a promising sign. Poor levels of nutrition, lower levels of physical health, higher levels of overcrowding, higher levels of mental health issues, higher levels of substance abuse, higher levels of sexual abuse, higher levels of domestic violence, higher levels of unemployment, reduced life expectancy, and significant language issues. Now, that's a terrible catalogue. But it's hardly surprising then if people that suffer from those disadvantages are going to be overrepresented in those who commit crime. And the gap, as we know, gets worse the more you move into regional Australia. So those gaps all get worse the further away you get from our capital cities. And the sad fact is, and until we address these multifaceted issues of disadvantage, Aboriginal people will continue to be overrepresented amongst those who commit crime. So let's move then to the second area that I mentioned. That's what I call systematic disadvantage. And let's track through the way the criminal justice system works, starting with police contact. Aboriginal people are much more likely to be spoken to by police, so that if 3 Aboriginal boys were walking through the streets of the leafy suburb in Perth in which I live and the police car drove by, it would be very likely that the police car would stop and ask them what they were doing there. And those boys, when that's happened to you 5 or 6 times, you're probably not going to appreciate that. You're probably going to answer with a bit of lip, which is then going to escalate into an altercation between the boys and the police, who are then going to be arrested for assaulting a public officer, resisting arrest, and so forth and so on. Then at the next level of the criminal process, after intervention with the police have a choice about whether they utilise what we call diversion processes, that is, taking people out of the court system or leaving them in the court system. Figures show that Aboriginal people are much less likely to be diverted out of the system and more likely to be put through the court process. Then police have a decision about whether to proceed by way of arrest or summons. If they proceed by summons, then there's no question of the person being arrested, but if they proceed by arrest, then the bail issue is enlivened. Aboriginal people are much more likely to be arrested than dealt with by summons. And when, because they are arrested, bail issues arise, Aboriginal people are much more likely to be either refused bail or unable to meet the conditions of bail. The next step in the process is the plea. Aboriginal people are much more likely to plead guilty than non-Aboriginal people. If they don't plead guilty and they go to trial, they are more likely to be convicted than non-Aboriginal people. And when it comes to sentence, Aboriginal people are more likely to receive a custodial sentence than a non-custodial sentence. A number of states, particularly my own state, has various regimes for indefinite detention for people like dangerous sexual offenders. Aboriginal people are significantly overrepresented amongst those who are caught up in those regimes. And again, in states like mine, where we have mandatory minimum offences for a series of offences, including quite minor property offences, Aboriginal people are significantly overrepresented in those regimes as well. And in the final step of the process, parole, Aboriginal people are less likely to be granted parole than non-Aboriginal people. So at every single step in the criminal justice process, Aboriginal people are disadvantaged. The question that poses is, can we say that the Australian justice system provides equal treatment to Aboriginal people? Now that requires us to identify what we mean by equality. When lawyers and judges talk about equality, they apply the notion of formal equality, which was attributed to Aristotle, and that is that things that are alike should be treated alike, whereas things that are unalike should be treated unalike in proportion to their unalikeness. The High Court put it this way, where in Green and the Queen, the High Court said, equality requires, so far as the law permits, that like cases be treated alike. Equal justice according to law also requires, where the law permits, differential treatment of persons according to differences between them relevant to the scope, purpose and subject matter of the law. And in Wong and the Queen, the High Court have said equal justice requires identity of outcome in cases that are relevantly identical. It requires different outcomes in cases that are different in some relevant respect. So the focus then of lawyers and judges is on what's relevant. And so the application of principle of equality depends critically on identifying the characteristics that are relevant. And in Bugmy and the Queen, the High Court confirmed that Aboriginality was irrelevant to the sentencing process. although circumstances of social deprivation often associated with remote Aboriginal communities were relevant to the sentencing process. So, applying Aristotle's notion of formal equality doesn't require Aboriginal offenders to be sentenced differently because they're Aboriginal, but it does require offenders who've suffered extreme social deprivation to be sentenced differently to those who've not experienced such circumstances, and it requires all of those who've suffered such experiences to be treated alike, irrespective of whether or not they are Aboriginal. On the other hand, sociologists are more inclined to assess the outcomes of any process for the purpose of ascertaining whether the process provides substantive equality to those who are subjected to it. As Professor Catherine McKinnon has pointed out in the field of gender equality, even though most Western democracies have had laws prohibiting discrimination on the grounds of gender for decades now, women in those societies remain significantly underrepresented in most areas of leadership. That suggests that the structures and processes which allocate leadership roles within these societies disadvantage women, and to that extent do not provide substantive equality to women. A sociologist might take the same view of a justice system in which nationally 28% of the prison population come from 2% of the general population, or in my state, 40% come from a particular group which comprises only 4% of the general population. A lawyer and a sociologist, therefore, might well arrive at different conclusions as to whether the justice system is treating those people equally. So let's return to the notion of equality espoused by Aristotle, and which has been adopted by the High Court, and ask whether the outcomes of Indigenous interaction with the criminal justice system can be attributed to unequal treatment. In the way in which lawyers look at these things, the Western Australian legislation, which authorises police to issue move-on orders against people thought to be committing a public nuisance, doesn't discriminate against Aboriginal people because it applies equally to anybody thought to be committing a public nuisance. By the same process of analysis, because people who don't, the bail legislation doesn't discriminate against Aboriginal people, because people who don't have a home or who are not in stable employment or who have a long prior criminal record are treated for the purposes of bail the same way whether they are Aboriginal or not. By the same analysis, mandatory sentencing doesn't discriminate against Aboriginal people because it applies to all offenders who come within the scope of that legislation, irrespective of race or culture. So in a lawyer's analysis, these laws can't be said to discriminate against Aboriginal people or to result in unequal treatment because they don't discriminate by reference to Aboriginality, but rather by reference to characteristics with which Aboriginal people are much more significantly associated. And the facts are that Aboriginal people in Western Australia are much more likely to be given a move-on order and arrested for failing to comply than non-Aboriginal people. Aboriginal people are much less likely to get bail, as I've already observed. Aboriginal people are much more likely to be caught up in mandatory sentencing regimes for things like property theft, and they're much more likely to be caught up in indefinite sentence regimes, either dangerous sexual offender or violent offending. Now, I think, with respect to my profession, the sociological approach espoused by Professor McKinnon makes rather more sense than the lawyer's approach. Put it bluntly, if one looks at the outcome of a system and sees that those outcomes are skewed, it's a fair inference that the system is not working fairly. We know that the outcomes of the criminal justice system in Australia are significantly skewed against Aboriginal people. Some of the sources of that skew can be seen in the examples I've given and in the shocking data that I started with. In my view, there can't be any doubt that Aboriginal people are significantly disadvantaged within our criminal justice system in almost every aspect of that system's operation. So even if a lawyer might describe the system's treatment of Aboriginal and non-Aboriginal people as equal, the outcomes of the system's operation are grossly unequal. Whether you attribute those outcomes to disadvantage or to discrimination, it doesn't really alter the tragic effects of those outcomes on the descendants of the longest unbroken cultural grouping on the planet. So the problems are profound. Are there any answers? What can we do to reduce disadvantage? What can we do to improve the provision of fair and equal treatment to Aboriginal people within the justice system? Well, in terms of reducing the multifaceted disadvantage to which I refer, these are issues for sociologists and policymakers, not for lawyers like me. My view, for what it's worth, is that over the last 200 years, non-Aboriginal people have done far too much talking and not enough listening. My view is that we need to focus much more upon empowering Aboriginal people like Sue Gordon to identify outcomes that work for Aboriginal issues. But there are some significant ethical dilemmas in these policy areas. And we go back to out-of-home care. The rates that I mentioned earlier shock the conscience. What should we do about it? Well, clearly there shouldn't be as many Aboriginal kids in out-of-home care. But if the home circumstances of those Aboriginal kids are appalling, what do we do about it? Do we say, well, because we want to keep the figures of Aboriginal kids in out-of-home care down, we tolerate Aboriginal children living in conditions that we would not tolerate non-Aboriginal children living in? That's a form of racial discrimination. But on the other hand, we know that if we take Aboriginal kids out of their homes and put them in other homes, we know that the long-term consequences are not good. The answers to these issues are not easy. Similar issues arise in relation to the cashless card. It's very difficult to justify the cashless card by reference to ethical or ideological considerations. It's paternalistic and it's discriminatory. But in a number of the areas where it's been introduced, it has resulted in reduced hospitalisations, reduced domestic violence, increased levels of nutrition, reduced illicit gambling. Same can be said of alcohol restrictions. From an ethical and ideological point of view, they are indefensible. They are paternalistic and discriminatory, except when they are introduced, they reduce domestic violence, they reduce hospitalisations. So there's the ethical dilemma. How do we deal with those sort of issues? I don't have the answer, I'm afraid, except that it seems to me that perhaps the best approach is to promote self-determination and again to allow Aboriginal people to decide what the answers to these issues are. As I understand it, that's the approach the federal government is taking in relation to the cashless card. And I'll return a little later to talk about involvement of Aboriginal people in governance. So let's talk about justice system solutions. And let's start at the beginning, perhaps, at causes. Justice reinvestment is a tag that some of you will have heard about. It justifies a lecture on it all on its own. I won't dwell on it. Basically, it involves the proposition that instead of spending massive amounts of money incarcerating people, we should spend the money addressing the causes of their criminal behaviour. In Western Australia, some years ago, a survey suggested that about 50% of the money that's spent by the state of Western Australia on Aboriginal people is spent in the criminal justice system, and that's just crazy. We are, and effectively, as my mother used to say, an ounce of prevention is worth a pound of cure, but we're not interested, doesn't seem we're interested in prevention. The more modern example is we've parked the ambulance at the bottom of the cliff rather than building the fence at the top. So something needs to be done about prevention. The minimum age of criminal responsibility in most states, certainly in my own state, is 10 years old. That, I think, is obscene. By international standards, it's indefensible. Even the Commissioner of Police, my good friend Chris Dawson, who's now the Governor of Western Australia, he suggested that the age should be raised to 12. There's a lot of support, I think, and I support the idea of raising it to 14. Some of you are shocked to hear that the Chief Justice and the Commissioner of Police were good friends. Let me tell you, there's nothing untoward about that. The reason we became friends was because police and judges and magistrates are at the coalface. We're exposed to the futility of the revolving door in relation to Aboriginal people in Western Australia. We know how pathetic the system and hopeless and tragic it is. So Chris and I were aligned on those sort of issues when we're both in office. We desperately need alternatives to juvenile detention. The focus has to be upon therapeutic care rather than upon punishment. No, so it's the provision of those alternatives that is the answer to lifting the age of criminal responsibility. Youth diversion is associated with this. We know which kids are at risk. In Western Australia, the dysfunctional Aboriginal families are very well known to police. So we know which children are within those families. We know the kids who are going to be at risk. But instead of intervening and taking positive steps, we sit back and watch the train wreck happen in slow motion. We should be providing much greater support for those families. We should be introducing positive programs, encouraging school participation, encouraging participation in sport, making sure the kids go through numeracy and literacy programs when they get old enough, making sure they get a driver's licence, dealing with issues of substance abuse, increasing employment within the family and reducing welfare dependency. If we did all of those things, we would find crime rates going down. Bail, I've already mentioned. With a lot of Aboriginal people, including children, bail has declined because there's nowhere for them to live. We have bail hostels now. They're in Western Australia. They're an improvement. They need to be out of town because if the kids remain in town, they're going to continue to be in trouble. For adults, the provision of bail hostels is really, really important, because the sooner, if somebody's homeless, an Aboriginal offender is homeless, the sooner you can find them somewhere to live, the sooner you can start introducing them to programs that will address the cause of their offending. And if an offender is undertaking programs prior to sentence, so if programmatic intervention starts early before sentence, the sentencing outcome is going to be a lot better, because that offender's lawyer can get up and say, undertaking a program, there is some hope. So the sooner we can get people into programs prior to conviction, the better. Legal aid, I have great admiration and respect for the legal aid commissions and the Aboriginal legal services around Australia, who do a remarkable job. They are all, in my view, significantly under-resourced, to the point where the people who work in those systems are stretched to breaking point. The dedicated young lawyers who join those systems are burnt out very quickly. We need proper resources for those. Interpreters. It might be hard for Victorian perhaps to appreciate that there are parts of Australia where Aboriginal people have very limited facility with English. The town of Balgo, or community of Balgo in the desert in the Kimberley, Aboriginal people there will speak 5 languages, 4 of which are Aboriginal, and the 5th and the least fluent is English. When the court goes to Balgo, we take interpreters there, but it's not just in the court process. Interpreters are needed when people are interviewed by police. They're needed when they're interviewed by lawyers. They're needed when they're interviewed by Department of Corrections officers. So we need much improved interpreting services. Traffic offences. Far too many Aboriginal people are in prison for traffic offences, and I don't mean drunk driving. I mean driving without a licence, and that's because far too many Aboriginal people don't have licences, and that's because there are language issues. There are issues in relation to getting up the number of hours that you need to get your licence. It's silly that we are putting Aboriginal people in prison for for driving offences that don't threaten anybody's safety. Fine default, another significant area. Aboriginal people are often fined, which is good. We don't want them going to prison, but then they lack the capacity to pay the fines. So what do you do when they don't pay the fines? And Western Australia, until recently, the answer has been that you imprison people. And tragically, one of the people who was imprisoned for that reason, Miss Dew, died while in custody in Port Hedland. Mandatory sentencing shocks the conscience at every level, but it, as I've mentioned earlier, applies far too often to Aboriginal people. In one case in Western Australia, an Aboriginal child got 12 months in juvenile detention under the mandatory sentencing regime for stealing $4 because he'd previously stolen a can of Coke. Now, if you wanted to find a really good way of putting that child onto a criminal trajectory, that would be a way to do it. That would be a pretty damn good way of making sure that kid graduates into the adult criminal justice system. Dangerous sexual offenders, as I've mentioned, I did a number of the cases. All the men that I dealt with under that legislation were Aboriginal. Many of them came from regional parts of Western Australia. If one has facilities like electronic monitoring and supervision, one can feel much more confident about releasing such people in the community. But those facilities don't exist in the regions from which they come. And if you release them into metropolitan Perth, they're going to struggle because they've never lived in Perth, and it's just not going to work. We hear sometimes about what we call postcode education in Western Australia. Well, we have postcode justice too, so that people who come from regional parts of the country don't get the same options as people who come from the capital cities. Aboriginal courts, mentally impaired accused, before I get there. If somebody is unfit to what we used to call unfit to plead, in Western Australia the legislation gives the court only 2 options. Either you dismiss the charge and the offender walks entirely unconstrained from the court, or you lock the person up indefinitely. There's no intermediate between those two. And tragically, some people, a man called Noble was one, ended up being locked up indefinitely for a much longer period than he would have been incarcerated if he'd pleaded guilty to the offences. So the result is that lawyers understand that using that legislation is often going to end up with a worse result, so the legislation has become totally unfit for purpose. We've known about it for a decade and nothing's been done about it. Aboriginal courts. Happily, this state leads the country in Koori courts, but they are needed all around Australia. They cost more money, but so does locking up Aboriginal people recurrently. We need a circuit breaker. It comes back to this notion that I've been hammering, I think, that is of Aboriginal empowerment and governance. And so we need to roll those out. Sentencing options. We need better information in relation to things like FASD. The Canadians, of course, have what they call Gladue reports based on a decision of the Supreme Court of Canada, which requires detailed reports to be written before Indigenous Canadians are sentenced. I don't know that I'd go that far, but we do need better information and we need much better regional options for people in remote parts of the state. But most significantly, we need Aboriginal-led programs. to deal with Aboriginal offenders, and those programs need to be sustainable. They need to be funded on a sustainable basis. They can't be dependent upon the goodwill of some individuals, because those people are going to be burnt out. So they need to be sustainable and renewable. And prison programs. While somebody is in prison, we have their attention. They're a captive audience. Why aren't we making better use of incarceration to improve numeracy, to improve literacy, to get people a long way down the road to getting a motor driver's licence, to dealing with their issues of substance abuse, dealing with their violence? These are missed opportunities. What I think we need in the justice system, and indeed across Australia, is a systemic reset of the relationship between Aboriginal and non-Aboriginal people, root and branch. And it involves, I think, empowering Aboriginal people to identify the solutions which will reduce disadvantage and provide fair and equal treatment within the justice system. Now, that's a terribly depressing address, so let's try and finish on a positive note. I'm apolitical, but I have to say that my heart sang on election night when our newly elected Prime Minister made as his first commitment to the Australian people the provision and opportunity for constitutional change to recognise Aboriginal people and to give them a voice in government. I've also been excited by the positive response which that proposal has received across the Australian population. In my view, this is not mere symbolism, although symbolism is important, but things like this, empowerment, improvement in governance, have the capacity to address some of the issues I've been talking about this evening. Now, Professor George Williams, as usual, has put it much better than I ever could. He wrote, "Aboriginal and Torres Strait Islander peoples have long argued for change to Australia's system of public law, including reforms such as through a treaty, recognition of their sovereignty and constitutional recognition. They've done so not because of abstract concerns about the state of the law, but because of their experience in living in a nation that has practiced discrimination against them. They've been denied the vote, had their children removed, been prevented from marrying, told where they could live and had their wages confiscated. The federal and state laws that brought about these actions were possible because of a national constitutional structure that doesn't recognise the existence of Aboriginal and Torres Strait Islander peoples and permits discrimination against them and others on the basis of race. The problem's not limited to the law. It's been recognised that Australia's legal structure contributes to a broader range of concerns. Research on subjects such as the social determinants of health shows how discrimination, disadvantage and exclusion can have a major negative impact on mental and physical health. It's hard to underestimate the emotional and other costs of being cast as an outsider in your own land. Experts have recognised this, and for example, the Royal Australian New Zealand College of Psychiatrists has said the lack of acknowledgement of a people's existence in a country's constitution has a major impact on their sense of identity and value within the community and perpetuates discrimination and prejudice, which further erodes the hope of Indigenous people. There's an association with socio-economic disadvantage and subsequent higher rates of mental illness, physical illness and incarceration. And that view is not limited to lawyers or psychiatrists. Professor Fiona Stanley, another Western Australian, who also happens to be a friend, I should say, of course, because she is Western Australian. She's an epidemiologist. She spent decades working in Indigenous communities. She's expressed the view that marginalisation of Indigenous Australians and their virtual exclusion from Parliament and policy making is a major reason for their current poor outcomes. She also said, in spite of this, their resilience and strength is extraordinary. Giving them the power to influence and change is urgent. National and international studies on colonised Indigenous peoples show clearly that when they are able to implement the solutions developed by them, the outcomes are far better. Our research, and this is Professor Stanley, has shown that the impact of previous practices of marginalisation and removal are responsible for a large part of today's trauma and First Nations circumstance. Now, I don't pretend that constitutional recognition is a magic elixir which will solve the multifaceted disadvantage that I've described earlier, but I do believe that formal recognition and enunciation of an appropriate relationship between Indigenous and non-Indigenous Australians could provide the circuit breaker that we need to end the intergenerational cycles of trauma, disadvantage and dysfunction, and which would empower our First Nations people to take responsibility for policies and programs which are needed to address these issues. Now, of course, the Voice proposal has excited some ill-informed commentary. Contrary to that commentary, the Voice is not novel or unique or radical. The United States, Canada, New Zealand and Sweden all have provisions which empower Indigenous people to participate in government. WA Constitution was itself amended in 2015 to recognise Aboriginal people. The sky didn't fall in, but it has to be said that mere constitutional amendment is not enough. You need to go further and implement policy change. At the federal level, it's not going to be easy. since, of course, we require a referendum. You can amend state legislation simply by Act of Parliament. Federal level, you need a referendum. There have been 44 since Federation, only 8 have been passed. The last successful referendum was in 1977, 45 years ago. So in order to have voted in a successful referendum, you've got to be over 60. The last referendum was in 1999, 23 years ago, and it failed. This was the referendum on the Republic. Even though a majority of Australians support a Republic, the referendum failed. Nevertheless, I remain optimistic about change. I think it can be achieved, and I really hope it can be achieved. But it's a good start. But it must be remembered that the proposal that's currently before decision makers is at Commonwealth level, and it's a voice into the legislative process. Most of the issues I've addressed tonight need to be addressed at state and territory level, not Commonwealth level. And many of the issues need to be addressed within administration, within government administration rather than within the legislature, and some of them need to be addressed within the judicial branch. So while the Commonwealth will provide a very good lead, if that lead is to be effective, the states and territories need to follow that lead and expand the influence of the bodies that they create, representing Aboriginal people, with a voice not just into the legislature, but also into government administration and to the judicial branches of government. And if that happens, and I sincerely hope it will happen, after more than 200 years of injustice, we might at last be able to say that we're finally on the right path towards the provision of fair and equal treatment to the first peoples of the continent we all call home. Thank you very much for your attention.
Thanks so much for that, Sarge. There'll be a formal vote of thanks from Eddie Cabillo, my colleague Dr. Eddie Cabillo, after this, but there's an opportunity now for questions from the floor if anyone would like to ask one.
Peter Norden, Deakin Criminology. Thanks very much for your presentation. I'm sure it's affirmed in all of us a desire to see a change in this before our lives are over, people of our generation. I want to ask a question about the possible role of the legal profession in public advocacy rather than in law reform. Some of the dramatic negative changes we've seen in Victoria have resulted from law reform. Gargazulas committed a crime in Bourke Street and killed several people, and after that the presumption of bail was reversed for everyone. Bailey was a fellow who raped and murdered an ABC employee, and as a result of that the purpose of the parole board in Victoria was completely changed so that people only got parole if they didn't need it. In other words, they posed no risk. They weren't an 18-year-old homeless, or they weren't a repeat sex offender. So the law reform that's happened in Victoria, and I presume in many parts of Australia, has all been negative. And I'm wondering if you could comment on the role of the legal profession in Western Australia, particularly around public advocacy, the voice of the lawyer rather than law reform.
There is an important role, but the problem, I think, is that people diminish the statements, public statements by lawyers, because they say, well, they would say that, wouldn't they? So I think, if you've got other people who are less partisan, perhaps, who are speaking out on these topics, including judges perhaps, might carry a bit more weight. And certainly I spoke out on these topics when I was a judge, probably putting a few noses out of joint. But the parole system is very much, in Western Australia, is very much like what it is in Victoria. We give parole to people who don't need it. So instead of, identifying offenders who need support and supervision when they go into the community, introducing them to their parole officer 3 months before they leave, then getting the parole officer to find them somewhere to live, making sure they don't associate with their previous bad contacts, finding them some job interviews, making sure they're tested for substance abuse. Instead of doing that, what we do to the people who are at higher risk, we take them to the door of the prison and we say, here's your belongings, see you later, in the confident expectation that we will see them later, because of course they're going to come back. So unfortunately what's happened is that parole is seen in the public eye as a soft option, rather than as a means of making the community safer. Now, of course, people are going to commit offences while they're on parole. It's in the nature of human beings. So the question is not whether they reoffend. The question is, what is the acceptable level of risk of them reoffending? And what is the overall benefit to be derived from parole compared to no system of support when people leave prison. Now, that's more, I think, of a sociological type of issue, but it needs, I think, people like you, with respect, to be doing some of the analysis, the data analysis, and showing what impact parole does have on reducing offending. Because if you can demonstrate to people that systems actually make the community safer, then it's hard, because people's intuitive reaction is that if we increase punishment, that will somehow make the community safer. Well, if that were true, America would be the safest place on the planet. Last time I was in the USA, it didn't strike me as the safest place on the planet.
I do have a sense too that not all of our law reforms are evidence-based, and I get that from your talk as much as anything. Are there any...
A lot of them are politically. A lot of them are
Absolutely.
politically driven.
Yeah.
And most state governments, I don't know what it's been like in Victoria, but most state elections, there's a law and order auction where each try and outdo each other by threatening to increase sentences. It's just ridiculous. If there was any evidence that it worked, maybe it'd be useful, but there isn't.
There's another question in the centre of the room.
How do you educate the general public into realising that most people in prison are not bad people?
I wish I knew the answer to that. I mean, the only way I could find when I was Chief Justice was 100 people at a time in public lectures, hoping that some of them would go home and tell their family. But it's very, very difficult when you've got shock jocks and newspapers out there portraying everybody who's in prison as if they're, terrible people. I mean, the reality is, if you go to prison, most of the people there are mad or sad. They're not bad.
So you're just going to continue thinking that prisons are just places to punish people instead of what they're really meant to do?
Yeah, exactly. They're just containing people. They're taking people out of circulation. Now, again, that's a very expensive and very ineffective way of reducing crime, because you've got to release them eventually. And if you're releasing them without support or supervision, without any programmatic intervention, why do you think they're going to be any different to when they went in? It's ridiculous. It's naive.
Just sort of taking up that point, what responsibility do you think that lawyers and judicial officers have then for perpetrating the, in my view, falsity that increasing sentences does offer a benefit? And specifically, courts again and again say, well, we impose this sentence for the purpose of general deterrence, to deter others. It's an empty box, but why do we keep doing it, and what responsibility do we have?
There's a limit to the judicial power. Judges have to act in accordance with the law, and there are sentencing ranges that are, again, usually set by this notion of deterrence. You'll gather from what I say that I don't have a great deal of confidence in general deterrence, but it is part of the process that the community expects judges to undertake. So there is a limit on the capacity to move away from that. The area of endeavour really ought to be in the legislatures. But again, it's politically unpopular, because if you're seen to be soft on crime, that's political death. So you're really inviting politicians to sign their own death warrant to have a system that is as compassionate as I think it ought to be. That's, I think, part of the problem.
I think we've got time for maybe another question. If there's... Jamie, did you want to...
Thanks for a fabulous presentation. Following up on the issue of sentencing, I guess I'm wondering, in the Pathways to Justice report of the Australian Law Reform Commission, they suggested that there was a need to address what the High Court had done in bargaining with this formal notion of equality that you had spoken about, by instead having a more substantive notion that accepted prima facie the system of Indigenous disadvantage, but then also was accompanied by the use of Indigenous experience reports, which are equivalent to Gladue reports, to help provide the specific contextual evidence in a case. But you seemed to indicate that you didn't think Gladue reports, we should go that far.
Gladue's become an industry in Canada, as you know, and as you probably know, and I think it's $20,000 to $30,000 per report. So that there are people who are making substantial amounts of money right now. I just think that money could be better spent. So we need to know more about it. Part of the problem is that if you've got an Aboriginal person who's spent all their lives in the suburbs of Perth, their position is going to be very different to an Aboriginal person from the remote community in the Kimberley. So you need to know about the offender, but don't necessarily need to know the conditions in the community. If you've got a magistrate who circuits to that community, they're going to know what life in Balgo's like. So you don't necessarily need a report, but you do need to know about that offender's childhood, about influences and impacts, whether there are supports available to that offender within the community, that sort of stuff. But that should be capable of being achieved without the sort of going to the entire lengths of GLADU. But I do think we certainly need more sentencing information, but especially we need more sentencing options in those places, non-custodial options, because often if you're in Balgo, there's no alternative to, it's either basically nothing and no supervision or prison. There's nothing in between, whereas in metropolitan areas you've got much more option. So sentences tend to default to prison circumstances where they wouldn't if they were in the metro area. And that's bad.
In the profession, we're reluctant to be, as you said, listen. And the reality is you can walk out of law school and represent an Indigenous person if you've never seen one before in your time. And I've been on the Law Council Indigenous reference groups for about a decade, and the profession is really slow in looking at itself and accepting that there's a need for ongoing accreditation in this space, where if we look at other professions like nursing and the medical professions, if you're going to practice in that space, you need to get accreditation. In our profession, we're very reluctant, and that's despite people like yourself and former Chief Justice Bathurst saying there's a huge unconscious bias problem within our sector. And also the Council of Australian Law Deans have come out and said that the curriculum of the legal curriculum is racist. What do we need to, you said we need to stop and listen, but what does our profession really need to do in regards to addressing this?
More Aboriginal lawyers, it's a great start. That's happening, but it's taking too long. But we need more Aboriginal lawyers. But also, I think your idea of accreditation is good. Go back to FASD, which has driven me nuts over the last decade. I've been railing about FASD, which is an acute problem in remote Western Australia for years, but there are still cases that came before me where FASD, a diagnosis was obvious on the offender's history. Experienced defenders, experienced report writers didn't even ask the question about whether FASD was there. Now, if it's there, it's a very significant mitigatory factor because, of course, it's a condition that somebody suffers through no fault of their own. And people are missing it. So if you had a process of accreditation, people who've gone through that process would say, well, they'd have a checklist. FASD, is it there? If so, what do I need to do to get this person tested for it? I think you're right. I think it's a specialist area. You need accreditation. The problem is, of course, that if you impose accreditation on people and say, oh, and by the way, the prize for winning this accreditation is that you get to work 12 hours a day in some of the harshest parts of the country, it's difficult, which is why we need to throw more resources at those poor people. So.
Thanks. Over to you, Eddie.
I just want to got a gift here for yourself. But so when they asked me my opinion on who we should get to come and give the lecture, I actually threw your name up.
Oh, thanks.
As an Indigenous person from the Northern Territory, where I'd say the statistics probably be would rival Western Australia, if not surpass them in regards to per capita. But
per capita, Western Australia is worse.
Yeah.
Absolute numbers, Northern Territory is worse because you've got a high proportion of average, but per capita it's worse in Western Australia than it is in the Territory.
So the reality is, for an Indigenous person from the Territory who practiced law and studied law, as you said at the start, it didn't, what was being taught didn't replicate what was affecting me. Just recently I was racially profiled and pulled over and had my tyres kicked for about an hour. But the reality is that someone of your ilk, and like I mentioned, Chief Justice Bathurst, who, whilst at the bench, you actually did critique the profession and the issues, which is very unaccustomed for Indigenous people to see and hear. But so that's the reason I wanted to sort of have you come and speak to a fairly privileged place like the Melbourne Law School to get students and others to hear someone's point of view that's been at the coalface himself and sees the actual injustices that are happening. So,
it's been my absolute pleasure, Eddie. Thank you very much.
that ends tonight's formal talk. So thanks all for coming, and I'm sure we can stay around for a few minutes if anyone's got any questions they'd like to ask of the judge before they leave. Thanks, everyone.